If someone has a registered trademark, it's just very powerful. It's per se evidence in court. I mean, it's just very, very powerful. So if they have a registered trademark, you're largely out of luck, which is why it's so important to have a federally registered trademark.
Let me introduce Josh Becker, who is a popular independent author, and that's how Josh and I met. We both belong to an indie author group for children's book authors, and he's also employed at the trademark office. So he has a deep knowledge and understanding of trademarks. And I'm going to pass it over to Josh to continue to provide a little bit of information about his background, and we can go ahead and get us started with some questions. So Josh, why don't you go ahead and tell us a little bit about your background?
I'm happy to be here. I'm grateful to be here. We're going to have a good time. I graduated from law school in 2007. I always wanted to go into intellectual property, copyrights, trademarks, entertainment law. I wanted to help artists. I also wanted to be an artist myself. It's been a long journey, but in short, right now, I spent many years representing artists and authors in the private sector, and now I work for the government. So I'm kind of on the other end, and I work for the United States Patent and Trademark Office. I exclusively do trademarks. I accept trademark applications that are coming in, and I examine them, and I accept them or refuse them. So hopefully I'll be getting some trademark applications from some of you, or my office will. Yeah, and I'm happy to answer any questions at all.
Tell us, why would someone want to trademark something, and what should they consider trademarking?
That's a great place to start, April. Thank you. Because I'm a trademark lawyer and I am also an author, I have that unique angle that I'm able to see trademarks, but from the perspective of an author. So for independent authors, what you probably want to protect are three things. Most importantly, I would say the name of your book series. Secondly, might be your author name, your actual legal author name as an author. And thirdly, perhaps your publishing company, if you have an LLC that you're publishing your books out of. Those are three things that you might want to protect and register as a trademark. And those three things might come, each of those three things might come in various forms. It might be the wording of your publishing company, book series, or your name. It might be a logo design. It might be a logo design with wording. It might be a logo design without wording. Each of those things that you want to protect would be a separate trademark application. I always like to use the example of Nike. We know like the athletic clothing company Nike. So they probably, because they have an unlimited budget, they probably wanted to protect themselves. So they probably have one trademark over the standard characters Nike, the wording Nike. We call that a standard character application. Then they probably have another one on the Nike swoosh. Then they probably have a third one on the word Nike with the Nike swoosh under it. Then they probably have 10 others of the Nike swoosh in all different colors, gray and green and blue and red, so that they could stop other people from using a similar design in those colors. So, and then they have the trademark Just Do It, and then they have Just Do It under the Nike swoosh. My point is there are multiple ways you can do this, but if you have a limited budget, the best way to start is to just protect the wording. So again, the wording of your author name, the wording of your publishing company, or probably most important to the people in this meeting now, the name of your book series. A lot of people are surprised to hear that you actually cannot protect the name of a single book. You cannot get a trademark registered for the name of a single creative work, such as one book or one movie or one song. It's just, we don't consider that use in commerce. You're not using it as a brand name, which is what a trademark is. A trademark is legally defined as a source indicator. And when you're using it as the title of one book, it's not showing what company the book came from. It's showing what the book is called. So we don't protect that.
Could you explain a little bit more about why should we get the, say, my book series trademarked? what would be the problem of not doing it? I guess that's kind of the other side. What do I put at risk by not protecting those things that are like my logo, my those important things that you just mentioned?
Right. So the obvious, I mean, the quick answer is there's several answers to that, but the quick answer is that somebody else could steal it from you. Somebody else could register the trademark before you did, and then they could actually stop you from using that book series name. So if you're investing a lot of time and a lot of hours and a lot of your money and your emotional capital and your time into building a book series, to spend, $200 or $300 on a trademark application so that for the next 20 or 30 or 40 years, the name of your book series is protected is, the price of that pales in comparison of the price of not doing so often. So, Harry Potter, that's the name of a book series. If the author of Harry Potter did not get a trademark on that, then someone else could have possibly, started a new series called Harry Potter or Harry Putter or Barry Potter. And they could say, she doesn't own that. And I do have the trademark. Not only can I do what I'm doing, is I could actually stop her from doing what she's doing. So you're protecting your series name. Now, it does get a little bit complicated because it doesn't really go by who registered the trademark first. It also depends on who has been actually using it first. So you don't technically need a registered trademark to it gets complicated. I could talk about it more, but basically, when you get a federally registered trademark, you have a new weapon, very, very powerful weapon that you could use in court if you need to say, on this date, I was using this trademark, I registered it. Not to get too much into the weeds, but when you registered a federal trademark, you automatically get rights to use that trademark throughout the entire country, really throughout the entire world. Well, we'll stick with the country, throughout the entire country. The only way someone could stop you is if they say, well, I was using it before you, and they would have to prove that they became famous and well known in a certain geographic area, and they would have the burden of proof of showing that. And once they showed that, you would still have the entire country minus that small geographic area. But that's very hard for them to prove even. So the point is, it's very important to get a federally registered trademark as soon as you can.
I also have a publishing company called Little Labradoodle Publishing, and I didn't trademark it. I'm not like so tied to it that if something happened, it would be a big deal for me. However, it is something I'm considering getting trademarked. It does have a logo and other things that I have tied to Little Labradoodle Publishing. So if somebody came back and said, I have this, you can no longer use that, what happens to that for me? And what do I have to do if something like that were to happen?
If someone came to you and said they're using Little Labradoodle Publishing first. So,
Yeah.
I mean, it depends. If someone came to you and said that, I would say to them, do you have a trademark? That would be
Right.
the first step. I mean, if someone has a registered trademark, it's just very powerful. It's per se evidence in court. I mean, it's just very, very powerful. So if they have a registered trademark, you're largely out of luck, which is why it's so important to have a federally registered trademark. And April, if you do have a registered trademark, once you get your registered trademark in Self-Publishing Made Simple, no one could do that to you. I mean, you have the trademark.
Right.
So it's very important to have the trademark. If that person doesn't have a trademark, then you and them could get into an argument about who started using it first, and you both would have to argue about it and prove who was using it first with evidence and who is more well known for it, et cetera, et cetera. But it's messy and it's subjective and it's unclear because no one has a trademark. Once you have a trademark, things are much more clear and you have you're the default winner unless the other person, could overcome a huge burden of proof that they were using it before you and et cetera, et cetera.
That type of a
Yeah.
battle end up being like something that happens in court? Is that what you have to take somebody to court to have them
It
stop
depends.
using it?
Well, it depends. I mean, before a lawsuit is filed, the two attorneys would communicate back and forth. And if one had a clear case against the other, like I have a federally registered trademark, then the person without the trademark wouldn't take the other to court because they would know they would lose. So
Right.
they would know they would lose. So there would be a negotiation.
Mhm.
And if that negotiation results in an impasse, then one of the lawyers may or may not spend the money to bring a lawsuit in federal court, but it would
Okay.
have to be worth their time. So, the potential damages would have to be high enough to justify the cost of going to court. So if
Right.
it was a tiny case with an indie author who, sells 200 books a year, then it might not be worth it to
Mhm.
bring it to court.
Tennille asks, if someone did register my book series before I did, would I have to unpublish all of the books already published, or would it only stop me from using it with future books?
Technically, legally, in theory, you would have to stop infringing their trademark. You would every single book that you sell, you would be infringing trademark law. You would be breaking the law. If a month ago I thought I want to start a beverage company and I made this like brown, sweet, sugary, bubbly liquid and I put it in red cans and it's sitting in my garage and I call it Coca-Cola because that's what I want to call it. I mean, even though I bought the inventory and it's sitting in my garage, that doesn't mean I could go to the supermarket and start selling my Coca-Cola because I would be infringing the trademark of Coca-Cola. I would be breaking the law. It might even be considered fraud, criminal fraud. I don't know if that's true or not, but I would be breaking trademark law for sure. So you would have to, technically, you would have to stop selling.
I think that would very likely require, Tennille, for you to change the series name and put
Yeah,
those things into a new series. And, if you've got your series name stamped on your book somewhere or anything like that, which
right.
does happen, then that can also cause more problems because you have to then redo all your covers. So it can be a good idea to spend some time doing trademark searches and even making sure that you have your trademarks so that this kind of thing doesn't happen in the future.
There's
Yeah,
one
okay.
important thing that I left out because we're talking about we're in a race, right? I want to get the trademark before the other person does.
Right.
So I just want to point out the winner of the race, meaning the person who gets priority, we call it priority. It's the person who submitted the application first. It is not the person who gets their application registered first. If you apply for a trademark today and someone else applies for that same trademark tomorrow, and that other person gets their trademark granted first, like in 6 months from now, and you get it granted in 8 months from now, you still win because you applied for it first. So you have to understand trademark rights begin retroactively from the date that you first submitted your application. So I'm just going to say that one more time. When you get your trademark registered, that means approved, your trademark rights start retroactively from the day that you first filed the application. And that's why you want to file the application as soon as possible. The United States Trademark Office does not require you to have a lawyer to file an application. You are allowed to file an application without a lawyer, but we recommend in most cases that you do have a lawyer do it because it's tricky. But if you
Right.
want to spend 20 or 30 hours on YouTube watching videos about how to file the application, I mean, you could do it yourself. It's not the hard, you could ask April how complicated she thinks it is.
I did go through it myself without an attorney. And of course, I pinged an attorney that I do know to get some information when I needed it. But it was, I mean, it's a little convoluted, but my understanding is that they also have some like step-by-step and videos that you can,
Yeah.
where you can go through some training, and you can even join like some sessions and ask questions of the USPTO, the office, so that if you are trying to do it yourself, you can get some support, which I don't know how long they've been doing that, but I think that's brilliant that they're helping people so that they don't end up getting stuck.
Okay, so let's look up the trademark, but then I could talk about classes because April, you're
Yeah.
saying you applied for publishing, but I think people don't understand yet that when you file an application, you actually have to write what you're filing it for, like what you're doing. Is it the name of a book series? Are you
Right.
selling sneakers? Are you giving dental services? Are you giving toys, sports equipment, books, publishing services, construction services? I mean, you have to tell them what you're doing under the trademark. And the reason is because you're only going to have trademark rights over those goods and services that you're saying that you're putting out into the world. So Edie says, on her application, I'm putting out into the world printed storybooks. That means that if someone wants to open an ice cream store called Breathing Love and they apply for the trademark Breathing Love for ice cream parlors, their application will not be refused based on Edie's registration because they're in a completely different industry. So when you apply for a trademark, you have to tell the trademark office, you have to type into the application what you're doing. And the more things you type, the more money you're going to have to pay generally. That gets a little complicated, but you could just say a series of books, and that's one thing. If you want to do publishing services, that's another thing. If you want to do ebooks as opposed to printed books, that's another thing, but it gets complicated. But between you and me, when you get a trademark for printed books, you're pretty much covered on ebooks as well, and vice versa. So you don't really need to worry about that. Okay, let's all go to the trademark office's website together. It's uspto.gov, which stands for the United States Patent and Trademark Office. Once you're there, there's a few ways to get to where we want to go. You could click on trademarks here, or I like to go here, find it fast. See, find it fast. So you could click on trademark search if you want to do a search. Everything is here. T's and forms. You could probably click on either one, but you probably want to click on T's. That is for doing the actual application. But right now we're going to search for Edie's mark. So we're going to click on trademark search and we're going to type in Breathing Love. And then we're going to click enter. And it's the first one that came up right here. This is the trademark Breathing Love. The arrows here, you could collapse or expand any section here. So goods and services, she wrote printed storybooks in class 16. So I'm just going to say this quickly because we keep skirting around it. It's so important, but it's a little bit complicated, but it's so important. The United States Patent and Trademark Office has a list of every good and service you could imagine. Dental services, restaurant services, construction services, and then there's goods like books and candy and sports goods and medical equipment. We have a directory of tens of thousands of these goods and services. They are separated into sections or categories called classes. And when you file a trademark application, you pay whatever you pay, about $230, $250 for each class that you choose a good or service from. So Edie has printed storybooks in class 16. For the same price that Edie paid, she could have listed 20 different things in class 16. It would have been the same price. She could have listed stickers, magazines, newspapers, because those are all printed things. But once she picks something from a different class, then she would have to pay another $225 or whatever it is. You're going to have to send the trademark office proof that you're doing that. So you don't want to lie and just say you're doing stickers and magazines and newspapers if you're not, because you're going to have to show proof that you're using it in that way. So right now, if you click on documents here, does everybody see my screen?
Mm-hmm.
You could see chronological order all the documents that Edie gave the trademark office and that the trademark office sent back to Edie. So first there was the application on the bottom. Everybody here should write down that Edie filed, it's called a T's Plus application. I'm not going to go into what it means, but it's just the best one. It's the cheapest one. It's the easiest one. And it's the kind you should all, it just means you're going to communicate by email instead of paper. And it means a few other things, but it's just simple and easy. So you should all, if and when you file for a trademark, you should send in a T's Plus application. And then on February 7th, Edie's trademark got refused for whatever reason. And then on August 5th, she responded to the refusal. And then on September 7th, it was refused again. You know, you could see all this. And then whatever Edie's lawyer did, they got the trademark through. So, oh, they did an amendment, they changed a few things. And then on March 22nd, it was published, which is one of the checkpoints, and soon it'll be on its way to registration. On November 7th, Edie's lawyer sent in the specimen, which is proof that she's using the trademark. And if you click on it, you could see it. There it is. So, oh, wait, they took this? This is only one book. Your trademark is Breathe Love. Where's your, oh, and it's right there, Breathing Love. So they accepted the specimen and it's on its way to being registered.
So if you happen to be looking up or searching for a potential publishing name or anything else, and you see there are other people that have filed, you have access to all of the things that they filed for, so that you can kind of brainstorm with your attorney or figure out whether or not they're doing in the same class that you are, right?
Yes, exactly. So I just do want to emphasize, when you all do a trademark search on the website, it's good that you do that, but it's often not enough. You should have a lawyer do it too, because a lawyer will be able to search within books. They'll be able to search for different misspellings of the trademark. It gets a little more complicated, but yes, you could go to the uspto.gov, click on Find It Fast, click on Trademark Search, type in your trademark, but also type in your trademark spelled in different ways. And also type in your trademark in singular and plural tense. If your trademark is mom and dad, try mom and pop, and ma and dad, and mother and father. You know, search for all of those and see what you find. I see there's a basic here, and then you could search like an expert. Actually, have never seen this web page before because I don't do my searches from here. I do my searches from the back end. But look at this. We always want to click on word mark because we're searching for word marks. If you want to search, you know, some guy's trademark, you could look by owner too. Like if I'm looking up Dottie Lee's trademark, I could also click on owner here and type in Dottie Lee or the name of her LLC. But we're not doing that now. We're searching by mark, by word mark, which is another word for trademark kind of. And look, you could even refine by goods and services. I could write books here, so a million things don't come up. But let's not do that. Let's just look for Francis Flamingo. So I'm going to search it right now. So we have 613 results. Oh, so you know what? See how these say dead? That means we don't even care about them. They expired. Okay. So look on the left here. We're gonna uncheck the dead marks. We do not want to look at the dead ones. We want to look at the ones that are live. So I'm unchecking the dead. That's gonna get rid of 390 results. This is cool. I've never actually seen this because I don't search from this web page. Registered and pending. Does everybody see my screen?
Yes.
Yes.
Registered pending. If I want, I could what's the word? I could filter out applications that have been filed, but they have not yet been granted or registered or approved. But let's not do that, because we also do want to see prior pending applications, because we want to know who filed before us, who submitted an application before us. I wonder if I could do. Okay, so first I searched for the word Francis, and this is what came up: 4 different trademarks, and none of them are like Francis Flamingo. And by the way, the fact that these 4 trademarks are all coexisting and 3 of them are for books or ebooks, that's a really good sign that there is room for Francis Flamingo to coexist with them. So I want everyone to know I looked for the word Francis in books. Now I'm going to do Flamingo. For Flamingo for books, we have 8 results. We have Flamingo books for ebooks. Flamingo books. So we have 2 different Flamingo books. One is the logo and one is the words. They're both owned by Penguin Random House. But then we have Bold Flamingo, but that's for publishing services and author services. So that is related, but it's not necessarily. And I do want to say, like, we have our own back end search that we do, which is much more detailed, where we would write something like, I'll show you quickly. Do you see that code here? Do you see what I did? I or an E or a Y, you know, and I could have like 1 to 4 of them. So like 1 to 4 of these, and then like SZ or so that's why that this is something a lawyer would do.
Mhm.
Do you see what I'm saying?
Know the ins and outs, and lawyers
Exactly.
know the mistakes that have come up. So I guess since we're talking about lawyers also, I know that you do not do this service because you work for the trademark office. You're not allowed to help others. I love that you're here answering questions. So what should an author search for or consider when they're hiring a trademark attorney?
Do not hire a traffic ticket attorney, and it sounds obvious, but there are so many attorneys out there that don't do trademarks, but they think it's easy and they do it on the side. And they say, yeah, I do trademarks, but then you look at their website and it says divorce law and traffic tickets. And then in the bottom corner, it says like, we did a few trademark applications. I wouldn't hire them. And a lot of lawyers do that. There's so many lawyers that dabble in trademarks, and I would not hire them. You could tell in a second by the look of their website. If they do copyrights and trademarks, that's great because those two are very related. If they do corporate law and trademarks, then I would ask them how many trademark applications have you filed? And if their answer is anything less than 50, then then I would not hire them. I could give you all the name of two trademark attorneys that I know personally. If you want, you could contact Adam. I could put in the Zoom chat. Yeah, that's Adam at Kotak Law. He's one lawyer who's been doing it for he's been doing mostly trademarks for at least 15 years. And then I'm going to give you the name of someone else who's been doing trademarks since before I was born, I think. And he charges a bit more, and he's probably, well, he's amazing at what he does. I don't want to say he's better, but he probably, yeah. They're both excellent. Adam's been doing trademarks for probably 15, 20 years, and Paul has been probably doing trademarks for over 40 years. So I used to charge people like anywhere between $600 to $1,200 to do the search and file the trademark application. And that does not include the application fees that, like, let's say you were doing your own application. When you log on to the website, you have to pay an application fee. Is it 225 or 250, April? Do you remember? Or
I think it was
275?
I think it was 250, but I
I
could
think
be.
it's $250 per class, but usually you're only picking one class.
Mhm.
But it's $250 per class. A lawyer to do a search and file your application will charge you anywhere between 600 to 1200, well, 600 to $1,500. But honestly, don't pay more than 1,000 because there's so many lawyers that'll do it for 600, 700. If you get a refusal from the trademark office, your lawyer is going to have to respond to it, and that takes some time. So usually they'll say like included in your fee is like I'll take an hour of my time and try to respond to them. But if it takes more than an hour, then they'll charge you an hourly rate. And I don't know how much it is. I just want to say one thing quickly. Is that okay?
Yeah, of course.
If you get your trademark refusal, often your lawyer, and lawyers are going to hate me for telling you this, but often it'll take him like 10 minutes to fix the issue, and then your trademark is approved. And you don't want him charging you like $200 if he spent like 10 minutes. Here's a little trick you could do. Well, actually, you're not allowed to do that because you have a lawyer. Yeah, now that I think about it, if you have a lawyer, you're not really allowed to call the trademark office and talk with them about your application. But if you don't have a lawyer, you are allowed to. If you get a trademark okay, I need to show you all something quickly. I'm going to share my screen.
Okay. We get the insider tips. I love it.
Yeah, this could save you all a lot of time and money. USPTO.gov. Okay, Edie, what is your trademark again?
Breathing love.
Okay, I'm looking up Edie's trademark. You could look up your own trademark. By the way, when you register when you apply for a trademark, you should ask your lawyer, what is the serial number on my application? Because all applications are identified by a serial number. Once you have your serial number, you could call the trademark office, you could ask them about it, but you really can't if you have a lawyer. But if your trademark gets a refusal, like Edie's did months ago, if you open that refusal, on the bottom of the refusal, there's the name and the phone number of the person who's handling your application, and you could call them on their phone number, and there's no automated answering service. Literally, that person picks up the phone.
Love it.
And often the issue with your trademark application could be resolved in a 30-second phone call. I've already made 3 of these phone calls today to different people.
Mhm.
Some of them were lawyers and one of them was just some guy. So like this is your person to call if you have an issue. But if you have a lawyer, you're not really supposed to call. It should be your lawyer calling. All I'm saying is whatever any correspondence you're getting from the trademark office, at the end of it, there's a phone number. And that I just want you all to know, like, that phone number is the number of a human being in an office. And when you call it, their phone will ring and they'll pick up and they're nice. They do what I do. They are me. This is what I do. I have that phone number. And people call me and I talk to them and I help them with their application, just like I'm helping you all now. And they're not paying me a penny. Does everybody see that I'm on the USPTO.gov homepage? I'm under Find It Fast. Click on ID Manual right there. Does everyone see?
Yes.
And then this is the manual. This is very important. You might even want to save this link as a bookmark. I'm just going to show you around it. So I'm just going to like put in the word dog because I love dogs and that's what I do. Look what comes up. These are all the goods and services with the word dog in it. So like class 1 is chemicals. So chemical sprays used to aid in housebreaking dogs. Now let's do books. So let's sort by class. Oh, we're already sorted by class. So class 9 has downloadable nonfiction books in the field of class 9 is for downloadable stuff. So that includes ebooks and audiobooks. Class 16 is for printed books. When you submit a T's Plus application, what they make you do, and it's helpful for you, is you have to select which goods or services you're applying for from this directory, from this exact directory. So before you file a trademark application, you should go to this directory and look around. I mean, most of you are probably just going to want printed books, but check this out. So you could also do like series of printed fiction books, nonfiction books. But what Edie's lawyer did was better because you do not want to specify fiction or nonfiction because then your trademark rights will be limited to that genre. You just want to say series of printed books so that you have trademark rights over all genres. When you register a trademark on the name of your book series, that does not protect the content of your book. Someone could still steal your story. The way that you protect that, does anybody know? How do you protect that?
Copyright.
Yes. You have to also register a copyright with the Copyright Office over your book. There's a big umbrella called intellectual property, and under that umbrella, there's patents and trademarks and copyrights and trade secrets and rights of publicity and rights of privacy and a million other things. But yeah, so you want trademarks and copyrights are not the same thing. Trademarks last forever, by the way. Copyrights last, for the life of the author plus 70 years. They have different rights. They do different things. It's kind of like home insurance and car insurance, kind of, but they're just different, but they protect your intellectual property. And so trademark rights last forever in so long as you're actually using the trademark. And every 5 or 10 years, you have to show the trademark office that you're still using the trademark and pay like $100. It's during the 6th year of your registration and then during the 10th or 11th year. And then after that, it's every 10 years. I called a trademark applicant this morning and last night and the day before, and he finally got the phone today and emailed me back and said he's been getting so many spams. He's like, are you going to ask me for money? And I'm like, no, I just need you to make a little tiny change to your trademark. And I was about to refuse it, but because you called me, now it'll take us about 15 seconds to fix it. And now I could approve it. And then I approved it and he left. So get the phone and get your emails, but only if they're from an email address that ends in @uspto.gov. Because you will get a lot of email, and only get the phone if it's a number from Virginia, because the trademark office is in Virginia. It's in Arlington, Virginia, or Alexandria. I always mix them up. It's in Alexandria, I think, because a lot of companies will call you pretending to be from the trademark office, but they're not, unless their email address ends in @uspto.gov. Or their area code is 571.
I think we're up to AJ
Okay.
talking about a publishing colophone is a logo that's usually printed on both books, title page and spine. so that readers can recognize a brand. And she's asking if that's something that needs to be
Yep.
remarked.
Yes. Yes. You know what? Let's do this. I'm going to share my screen again. We could look up, like, I'll enter penguin and I bet a little penguin will come. Could everyone see my screen?
Yep, we're seeing it.
So I just entered penguin for books. Does everybody see this?
Mm-hmm.
That's a registered trademark. Well, that's some Japanese company. I actually can't find penguin for how many results came up. Oh, there's too many results. These are all these trademarks for penguin, and you could just see, like, a lot of them are logos and a lot of them are words and a lot of them are words with logos. See, penguin grenade. Look at that. A trademark could be, let me go back to Zoom. A trademark could be a word, it could be a logo design, it could be a sound. Like MGM Grand has a trademark on the lion's roar, and Intel has a trademark on that little jingle. It could be a color. I mean, this isn't relevant to most of you, 99.99%, but a trademark is just source indicating. Harley Davidson even tried to get a trademark on the sound of their bikes revving up, claiming that their bikes make a different sound than the other motorcycles. I mean, you could have a trademark on a color. UPS has brown for delivery. Pepto-Bismol has pink for medicine. Windex has blue for window cleaner. You cannot find another window cleaner that's blue unless they are paying Windex a licensing fee to be able to make it blue. And Windex made that famous. Now we think of blue window cleaner as like it's going to do a better job because it's blue. So yes, you definitely want to register your words and your logos.
AJ talked about law school clinics that help with the process. That's an interesting aspect. Would you recommend that, Josh?
Yeah, absolutely. I'm not so familiar with that part of my office, but we have a whole department based on trying to get out trademark, try to raise excitement and education about trademarks. So absolutely. My office's website is full of information and videos and articles that could help you. And it's all at uspto.gov. So anything on that website is great. Yeah, they do a boot camp. That's right. I applied to be with them and they didn't get back to me yet. But
Uh,
let's see, because I'm excited about trademarks and I like teaching people about them. Yes, go to that link that AJ posted. It would be very helpful.
what if you do most of the work and just want a lawyer to review it? Is that something that they would do as like a consult, pay for a consult?
I mean, yes, but a trademark application is complicated, but when you've done so many of them, they're very, very, very simple. So it's kind of the thing. If one of my client, if I was representing one of you and you were saying that, I would just say, just let me do it, and it'll take me. It's not hard for me. It's so quick and short. It's kind of like a surgeon to do a little surgery. They had to go to medical school and they do it all the time. So it takes them 20 minutes to do, but for someone else to do it, it would be very hard. So if my patient said, like, can I try to do the surgery myself and you could see what I did and try to fix it, it's just like, just let me do it. Like it would take me so little effort. It's so quick to do a trademark application. It could take me 15 minutes to do one. So just here's what, just it's, yeah, I don't know. You could do that, but I don't know if it's a good idea. I don't know if a lawyer would agree to do
Yeah.
it.
It sounds like maybe you were trying to save some money.
But it ends up being,
It might end up taking longer for them to unravel
yeah,
something that wasn't correct. Yeah.
yeah. So it's hard because I see what AJ's saying. Like, I get it. I mean, AJ, I would also say if you want to call, like, I don't know if Edie or April, well, Edie hired a lawyer, but I mean, maybe in this community, and maybe in April's community, there are people who did it themselves and who could tell you that you could talk to and they could give you advice. How hard is it? Did they get, I mean, you could try that. It's tough.
Yeah.
I don't know what to say.
Tennille's asking, she says she has a couple of different imprints that she's publishing under her company. Do those imprints require a
Oh,
certification? Her company name is Victorious Books, and then one imprint is Victorious Kids Press. So
right. So the answer to this question is, so you're saying, do you need to register them both? So if you have an unlimited budget, then yeah, it would be good. The more that you register, the stronger your trademark rights will be. However, if you do register Victorious Books and someone else tries to steal Victorious Kids Press, your trademark rights in Victorious Books is going to bleed over into Victorious Kids Press to a certain extent. So this isn't black and white, this is gray. It depends on a lot of things. So it's just budget related. Like, how much money do you want to spend? It's kind of what I said about Nike, with the Nike and the swoosh, and then the Nike with the swoosh, and then the Nike without the swoosh. The more that you register, the stronger your rights are in court, but the less that but if you have Victorious Books, I mean, if it was Victorious, yeah, kids and press are less important words because they're descriptive and they're at the end of the trademark. So once you have Victorious Books, you will have some protection for Victorious Kids Press, meaning you'll be able to stop other people from using Victorious Kids Press to a certain extent. I can't really say it better than that. I hope that makes sense.
Neil also asks, can ownership be transferred upon death of the owner? So how do you incorporate this for estate planning?
So I'm not a trust and estates attorney, but absolutely intellectual property, which means copyrights, trademarks, patents, any of that is absolutely transferable upon death in the exact same way that tangible property would be. And by the way, you could easily buy and sell copyrights, trademarks. People do it all the time. If Edie, I don't know if this is true, but if Edie filed her application under her individual name, so meaning the owner of the trademark is Edie Deering. If tomorrow, if Edie wakes up and decides she wants to she wants to transfer the trademark to her LLC, she could very easily write up a piece of paper that says, I, Edie Deering, am selling this trademark to this LLC for $5. And then she signs it, and then her LLC signs it. And then you send that into the trademark office. Ownership is just transferred. It's very simple.
Rick asks, can you review pros and cons of filing ourselves? Like what?
Yes, the
we
pro
tried
is
it.
you're saving the money on a lawyer, and the con is you might mess it up and it'll be horrible, and a lawyer will do a better job. But if you watch all the YouTube videos and you watch this and you're friends with April Cox and you remember that I said that if your trademark gets refused, you could easily just open the refusal, scroll down, and see the phone number of the person who's handling your trademark and call them and talk to them, and they'll help you. Then you could do it yourself. The only thing of doing it yourself is if someone got it first, there's nothing really you could do about it. So you have to do a search, but watch YouTube videos on how to do a search. And you could do a search yourself, and you could do it yourself.
You know, the other thing I can imagine is maybe you don't realize you should have gotten more than one class, and maybe somebody who's been doing this a while knows that that's a common mistake, and they might say, well, you might also, like for me, self-publishing made simple, books, yes. Then there was, like you told me, well, ebook is and audiobooks are separate, and I did want to do that as well. And I also just looking at things like services, like I wouldn't have known all of that if I didn't have somebody that I could talk to that could give me that information. And I could have very easily filed for one thing and left out critical things that I might lose access to later.
Right, right.
Yeah.
If you could do it yourself, also doing a T's Plus application makes it a lot easier. Understanding what classes are makes it easier. I think I said twice what a specimen is. You should all know what a specimen is. A specimen is proof that you're using the trademark. So the trademark office is going to require that from you. Yeah, the trademark office, I think, I don't know if I need to repeat it, but you should go back. I met with April and I explained what the trademark application will ask from you. And you should watch that presentation if you have access to it.
Yeah, from the Authorpreneur Summit, that was one of 36 different amazing presentations from the summit, and they're still available for those that purchase the premium pass. And if you have not and you're interested, you can still have access to it. So I will go ahead and also share that.
Also, what you should all do is, as practice, this is what I did when I didn't 20 years ago when I was trying to figure out trademarks. Go file a practice application, but then don't submit it and don't pay at the end.
Right, right. Yeah, that's a
Like
great.
go to the uspto.gov, click on quick find. I could show you all quickly. Okay, I'm going to the USPTO website. Could you all see my screen?
Yep, you're good.
Click on find it fast. Click on T's right here. See T's? Click on T's plus. Where is that? Okay, click on initial application forms, which makes sense, right? I mean, you'll initial application forms, and then click on start your application. Oh no, but then you have to like log in and all that. So you'll have to create an account, but I don't think it'll take more than 5 minutes. But anyway, yeah, I mean, that's a good thing to do. And then you'll see the trademark application. I'll just say very quickly, it'll ask you for the name, the full legal name and address of whoever you want the owner of the trademark to be, which will usually be you or your LLC. They're going to ask you, what is the trademark you want? They're going to ask you, what goods and services do you want to apply for under the trademark? And then they're going to ask you for something that is simple, but it'll sound a little complicated. It's called the filing basis, and you should write this down. There's 4 or 5 filing bases. The most important is 1A and 1B. If you do filing basis 1A, you're basically telling the trademark office, I am filing for this trademark, and the basis for my rights in this trademark is that I am using this trademark right now, and I am going to send you the specimen with this application. That is filing basis 1A. You should only do that if you're actually using the trademark. Filing basis 1B is, I am not using this trademark yet, but I'm going to soon. So within the next 6 months, I'm going to send you the specimen, and it'll cost me an extra $100 when I submit the specimen, but I'm still filing the application now for priority. So that's filing basis 1A, 1B. There's a bunch of other filing basis, but they're not important to this meeting. So those are the main things that, yeah, April put it in the chat. So yeah, and just file an application and then don't pay and don't submit it, but just do a practice one if you want. I think that's hugely helpful to do it without an attorney.
This time with you, Josh, has been amazing. What can we do? I know like you don't benefit by any of this other than the fact that you and I are kind of bartering. I want your expertise, you're getting my expertise on some Amazon ad stuff. But what can we do to support you? And because you are an independent author, how can we help you?
Thank you. My house needs to be cleaned. No, I'm just kidding. Thank you so much for asking. I'm the author of a children's book series on science and critical thinking that's educational, teaching children about big things like the Big Bang and space and science and animal evolution. And we just came out with a book called How We Found the Earth is Round. We have books about civilizations, ancient civilization. It's very educational and exciting. It's named after my children. It's called Annabelle and Aiden. So the name of my book series is Annabelle and Aiden. I just put the link in the chat, and I appreciate any support and sharing the love. And thank you so much.
It's always amazing for people to be able to get reviews. And yeah, so if you love those kind of stories or you want to support Josh, grab a copy of the book, provide a review. Those are like gold these days. So yes, please. And are you selling the books also from your website, Josh?
Yes. So I put in the link, annabelleandaiden.com. I put in the link. I'm selling everything from my website, and it's also on Amazon. So April, what's better? Amazon? Maybe Amazon.
It doesn't matter because as long as, I mean, if they purchase from your website, they can still go to Amazon and provide a review. It just doesn't end up showing up as a verified review, but it's still a review that gets tallied. So
right.
Regardless, I think it's amazing. And thank you so much for being here with us today, Josh. As always, this was an amazing discussion that you made something very complex seem a little bit more manageable, which is why I initially felt confident enough to submit the application for self-publishing made simple. And yes, everybody's saying thank you and spectacular. Our next self-publishing mastermind session, which by the way, guys, this mastermind, I'm rebranding, renaming the Authorpreneur Mastermind, because we are going to be digging deeper into authorpreneurial, right? Business stuff, the business of authoring, much more this year. And with the success of the Authorpreneur Summit and all of the huge feedback, great feedback I got from that, I feel like this is more in line with what we're doing. So our next session is the third Wednesday of the month at 1 p.m. Eastern. Our mastermind sessions are twice a month. If you're not a member, you can check that out on selfpubmadesimple.com. Go to those upcoming sessions. We do have some free sessions that anybody can attend, and we have lots of additional things coming, some exciting things around marketing and doing some brainstorming and some planning with Tara, who is an expert in marketing, Tara Kuvosi, who is the newest member of my team. And we are going to be pulling together some meetings and services and things to help authors with the most requested thing, which is marketing their books and getting more sales. So stay tuned. Lots of exciting things coming for 2024. I wish you guys all the best, and I'll see you again next Wednesday. Take care. Bye, everybody.